It's the little case that has become huge. We're going to talk about Trent Palmer's legal battles in the hangar. Welcome to In the Hangar. I'm Dan Milliken.
And I'm Christy Wong. Today's episode is brought to you by a lot of really great sponsors like Flying Eyes. We're going to talk more about them at the end, but I heard that there's some sort of case that's been going on the past couple of years.
So we're going to get right to it. You know, for those who don't know, Trent Palmer, 3-4 years ago, did a flyover, an inspection pass at a friend's house. He decided it wasn't safe, so he did not land. Neighbors got upset, complained to the FAA. Long story short, the FAA sided with the neighbors and tried to suspend Trent Palmer's license. We have Robert Schulte.
Yes, sir.
Who is Trent's lead attorney, right?
Correct.
So thanks for coming on.
My pleasure. Thank you for having me.
And talking with
So
us.
nice to meet you.
Likewise.
So Robert, real quick, give us a background, just a little bit more in depth for those who don't know what happened.
Sure. And during the course of your introduction, you were correct. There was a complaint, as most FAA enforcement actions begin with, that somebody, in this case Trent Palmer, attempted to land on a parcel of land in a community outside of the Reno, Nevada area. The neighbors had complained. The FAA came in, did an investigation, and concluded that Trent violated 91.119 of the Federal Aviation Regulations. We all know which one that is. It's the so-called 500-foot rule. Here's the problem, though. Trent was conducting an off-airport landing. No FAR prohibits off-airport landings.
Well, in addition, more specifically, the FAA guidelines for off-airport landings recommends it.
Correct. The off-airport ops guide, which is published by the FAA, does in fact tell a pilot how they should go about conducting an off-airport landing. And it's not like, obviously, a regular airport landing. You have to inspect the landing surface before you set down. That's what Trent was doing. The FAA not only recommends it, in their judgment, that's how you conduct a safe and prudent off-airport landing. You just don't land somewhere and hope it goes okay.
Right.
You need to assert for yourself to ensure that, in fact, landing surface is appropriate for the landing aircraft. In this case, this was simply a 10-acre parcel attached to the house and the property to where he conducted his approach, just like every other house out there. The neighbors didn't like it. They called the FAA in. The FAA concluded that he flew within 500 feet of persons or structures on the ground, and they violated him for it.
Now, there was some evidence, supposedly, that was like video of like, it was like a Ring doorbell camera or something where they caught him doing the low pass. Tell us about that.
It wasn't a Ring doorbell. It was an actual dedicated security system.
Okay.
The FAA, in their wisdom, instead of actually pulling a native video, took a video of the video playing on a screen, precisely.
Yeah.
That video, to be charitable, was of rather poor quality. However, it did show the pass. I asked the FAA inspector during the course of the trial what he actually did with that video. And he said, well, we took it back to the FAA and we downloaded it and put it on an FAA server and deleted the original video.
Why would they do that?
Well, that's a good question, but in my world, we have a word for that. It's called spoliation. I mean, you've destroyed evidence. Now, to be fair, the law judge did, in fact, exclude the video from the course of the proceedings. Unfortunately, he let everybody testify about what he saw in the video during the course of the proceedings. In other words, he closed the front door to the video and left the back door wide open.
So what exactly did they say in terms of like what they saw?
In most court proceedings, witnesses can testify as to facts, what they saw, what they smelled, what they heard, what they observed. They can't give opinions. I think he was flying too low. I think he was flying too fast. I think he was in a 30-degree bank angle. All right. The best way to show that is of the actual video evidence.
Right.
We can see it with our own eyes. The law judge, any other fact finder, sometimes in the case of a jury. But in this case, the judge simply let everybody offer opinions as to what they saw in the video.
So instead of saying, we saw him fly at 1,000 feet, for example, well, he was flying low, which is an opinion, not a fact.
Well, not only that, so the law judge excludes the evidence of the video and then allows the FAA's expert witness who really had, you can get into that, I'm sure, to testify as to how low Trent was flying and gave feet, like, 49 feet or whatever. He gave specific numbers. Where was he basing it on? Watching the video that was excluded.
Oh, okay.
Precisely. And
Gotcha.
it actually put Trent in a worse position.
Yeah.
Right, because I can't cross-examine a video that's not there.
That's been excluded.
And I
from
can't
evidence.
cross-examine a witness on something that they didn't see or hear or experience for themselves. They're simply testifying as to what they thought the video showed, even though the video itself was not in evidence. It was actually a very unfortunate, I think, frankly, incorrect legal ruling. In fact, it's one of the issues that's up on appeal.
Interesting. So were you guys able to go back and look at the video and make some calculations based off the video to say, no, he wasn't at 49 feet. He was actually flying at hundreds of feet above the ground?
I want to be very clear about something. Walking into this proceeding, we never disputed. Trent never disputed he came within 500 feet of persons or structures on the ground.
Okay.
Never disputed that. We had a 3-day trial over whether it was 29 feet, 51 feet, 68 feet. Vis-a-vis the regulation, it doesn't matter. Once you're inside 500 feet, the only question that becomes relevant is, was it necessary for takeoff and landing?
Gotcha. Okay.
That's what the regulation is all
Yeah.
about. The FAA's complaint in this case simply said you came within less than 500 feet of this structure, this person, this house, etc. Okay, so what? That describes virtually every takeoff and landing operation any pilot of any aircraft does.
Right. So what it does, so I guess your argument is that it sets the precedent for any off-airport landing or any landing for that matter. We're coming within 500 feet when we're coming in for a landing
If you do a
anywhere.
go-around.
Right, if you do a go-around.
Because if you actually had Trent actually landed, there wouldn't be an issue here. But because he didn't land, he deemed it unsafe, they're saying it wasn't a landing. It wasn't necessary for landing because.
So they're saying it wasn't necessary for him to be that low because he didn't
no,
land.
they're not. Well, being within 500 feet.
Right.
Let me play devil's advocate here for a moment. Let me be the FAA.
Yeah.
Oh.
Here's what
Okay.
the FAA would say. Relax. Go-arounds, practice approaches, practice instrument approaches. Don't worry about it. Those are perfectly fine. The rule actually doesn't say that. They say that. And they say, if you're doing a true practice approach, if you're simply doing a missed approach procedure, if you're just doing touch and goes, that's okay. Here's the problem with that. A, the regulation says nothing about that. And B, no pilot in the history of the world who has raised that as a defense in a case has ever won.
That is interesting.
Not one. There's not one reported case out there where a pilot has asserted, look, I was just doing a go-around. I was just doing a practice approach. When the FAA accused him of violating the 500-foot rule, has never been successful.
So go-arounds really aren't free.
Until now.
Yeah.
Here's what I'm driving at. What is necessary for takeoff and landing? What does that mean? Where's that defined in the FARs? It's not. And so what we're left with is when it's not appropriate or when it's not necessary, it's not a function of a federal aviation regulation. It's a function of a very simple concept that the FAA embraces wholeheartedly. Ready? Because I said so.
Yeah, that's a problem.
Do you know our country fought a war over that manner of governance? You know which one it was?
I'm pretty sure it was the Revolutionary
That's
War.
right. That's right. The rule back then was simple. The king was God's emissary on the face of the earth. And if you question the king, you're questioning God. Don't question the king. And that's kind of where we are. And that's the frustration intellectually for me with Trent's case. The case did not rise and fall on what is necessary per se for takeoff and landing. Where this ultimately went was the law judge concluded that the landing site was inappropriate for what Trent was attempting to do, and that therefore nothing he was doing with respect to that approach was necessary for takeoff and landing because you were never going to land there.
But Trent didn't know that until he did the inspection pass.
Right.
And that is the conundrum. The problem is that you don't know what you're doing is inappropriate or not necessary until after the fact.
Because it's not spelled out in advance.
And that is the complete antithesis of the rule of law. That's what the law is there for. Here's where the line is. Don't cross it. If you don't know where the line is until after you've crossed it, the line isn't very much good. as a law.
Well, and then when it's this nebulous, they're erasing the line and moving it to wherever they want because I said so.
Right. And so in Trent's case, the law judge concluded, and in my judgment, without any factual basis whatsoever, that the landing site was inappropriate. Now, where does that language come from? Because that's not in the regulation either. That's a function of case law. There are a variety of cases out there where, for example, a Learjet was doing a low pass over a 1,500-foot gravel runway. Was that inappropriate? Sure. Was it necessary for takeoff and landing? No, the aircraft had no hope of landing there. It was never going to land there. So that low pass, which in fact did fly within 500 feet of persons or structures from the ground, was inappropriate. The landing site was inappropriate and therefore not necessary for takeoff and landing. The evidence in Trent's case was unrefuted that Trent was capable of landing there, the aircraft was capable of landing there, and in fact the FAA expert, and we'll get to him in a moment, said he didn't dispute that Trent or the aircraft couldn't land there. He just didn't like it.
Did the law judge, does he have any experience with aviation at all?
This particular law judge was in fact a pilot.
Okay.
I can't deny him that.
Okay.
If he had any experience with off-airport landings, they certainly did not reveal themselves during the course of this proceeding.
Let me play devil's advocate for a minute and take the other side, just to so we because it'll be addressed in comments, I have no doubt. What if Trent was just buzzing them? What if because there was a feud going on between Trent's friends that own that property and the next door neighbors, and could it? That's what they are suggesting, that Trent was trying to buzz them, and they have psychological damage. Their child can't hear a motor now without freaking out, and all this kind of stuff. So, what if Trent was buzzing?
Okay, a couple of points. That the child might have been harmed intellectually, emotionally, what have you. That's a terrible thing. If in fact that occurred, that has nothing to do with 91-119. That's not.
But they brought this up.
Yes, they did.
Yeah. Okay.
We talked about all manner of things in this case that had
In the
nothing
3
to do
days.
that had nothing to do with the federal aviation regulations. Lions, tigers, and bears. Oh my, sure, okay, that's great. It's great fodder for conversation. But it fundamentally has nothing to do with the FAA's mission. It has nothing to do with that particular regulation. So what if Trent was buzzing? Simple. Allege that, prove it, and then suspend his license.
So I guess in that same tone, just speaking on for the other side, if they ruled in favor of Trent, this could set a precedent for
Buzzing?
low passes that aren't necessary with the guys that, I was just doing an inspection pass.
Listen, if in fact that's true, and lots of guys have done it, lots of guys and gals have been caught and been sanctioned appropriately, and they should be. Again, though, this is the government making an allegation against the pilot. You can't charge one thing and then proceed to trial onto something else. If I charge you with burglary and then you show up and all of a sudden you find yourself in the midst of a murder trial, that's going to be very surprising to you. And that's what happened here.
Yeah.
I suspect that the FAA believed that Trent was buzzing this house. That's not what was alleged, and that's not what they attempted to prove.
The inspector wasn't going to call the flag on this, but he's punishing him for something else.
I think there was a dynamic overlay of Trent's case that goes well beyond the particular facts of this proceeding. And it's this. He's out there on YouTube. He's a very passionate advocate for aviation. He's a very good advocate for general aviation, especially backcountry off-airport flying. I think some folks in the FAA view aviation as simply a matter to go from A and B and don't bank the wings between 5 degrees, and if you're having fun out there, you must be doing something wrong. I think that's unfortunate. I think most of us got into this because it is fun, and it's supposed to be fun, especially Part 91 general aviation. I think a lot of people enjoy just going out there and testing the limits of themselves and of their aircraft. There's nothing wrong with that. I think also that when a complaint comes in, as it did in this case, I think the FAA feels compelled to do something, even if there's nothing to be done. Respectfully, I think that the FAA on this particular day was not vindicating any notions of air safety, but rather the property rights of an aggrieved property owner. That is not their lane.
Right.
There are plenty of laws in the books that preclude aircraft takeoff and landings from private property. Lots of counties don't allow it. Lots of states don't allow it. Nevada does. All right, as long as you have the permission of the property owner, you can do it, period. The FAA does not concern itself with property rights law with respect to residential real properties. Listen, if this was downtown New York, we can all agree that was not necessary, it's inappropriate, but this is not. This was out in the middle of the Nevada desert. These were 10-acre parcels, and that Kit Fox 5 aircraft that he flies could embarrass a helicopter in terms of the takeoff distance and landing distance that
Right.
it needs. It can land in probably sub 100 feet, especially if it's landing into a headwind. And Trent, more than anybody, can do it. That the neighbors didn't like it really is of no concern to the FAA.
Well, where do we go from here?
Well, right now, we've gone through 2 levels of appeal. We are currently before the United States District Court for the District of Columbia. That's a federal appellate court. The next stop is the Supreme Court. I don't expect we'll go there, but we have oral argument next month on March 11th. I'm rather surprised, for reasons I'm not entirely clear on. We have gotten the attention of this court. Typically, they don't give oral argument in cases like this, but we're getting it. We have several complaints, not the least of which was the rather deficient manner in which the FAA pled this case. You just can't take a statute like 9119 and say you came within 500 feet of persons or structures from the ground and then say, come defend yourself. A complaint has to contain, at least at some level, the facts and circumstances that you're expected to defend yourself against. Were you buzzing? Were you doing something else? It wasn't necessary for takeoff and landing because of X, Y, and Z facts. None of that's in that complaint. When we went to trial, we didn't really fully understand where the FAA was coming from. For example, the appropriateness of the landing site was not alleged, was not pled in the complaint. That came about during the course of trial testimony. And even then, the FAA's expert, a man, doesn't matter what his name is, said, look, the landing site and the appropriateness of the landing site is a function of the capabilities of the pilot and the aircraft. Okay? Well, sir, what do you know about the pilot? Nothing. What do you know about the aircraft? Nothing. But you don't like that landing site, do you? Nah, it's terrible. Okay. So, when you give an opinion that has no factual basis, at least in the law, you shouldn't be allowed to give it. But he was. And the judge credited that opinion, even though it was to be charitable, uninformed. That's very frustrating.
He's on the payroll for the FAA, right? And he gets paid based on his performance of being able to testify in situations like this.
It's even worse than that. In most legal proceedings, each side hires their own experts.
Right.
And then each of those experts are exposed to what we call the crucible examination. I can test his theories. I can challenge underlying facts upon which he's using to inform his opinions. We can do all those things. But an FAA employee, oftentimes, especially in these administrative proceedings, is deemed to be an expert simply because they work for the FAA. But these employees, FAA experts, pilots, they can be mechanics, they can be subject matter experts to be sure. Not only do they testify before the FAA, they are precluded by law from testifying for anybody else. In other words, they have to testify on behalf of the FAA. In any other proceeding, they would be laughed out of court as being hopelessly biased. Here, it's business as usual. When an FAA comes into a proceeding like this and is testifying on behalf of the FAA, I promise you this, never will you hear him or her say, gosh, the pilot did nothing wrong. They're there to hang the pilot. That's what they do. They're simply there to put the imprimatur of what the FAA has already decided has happened. That's it. It's almost a show trial.
Is there anything that the flying public can do to advocate for cases like this?
There's been a movement for some time to simply take these cases away from the administrative law process and put them in federal district courts. I think if the airmen are truly going to get a fair hearing, a hearing where it's not stacked against them, it's really got to be taken out of this realm. Administrative law, for my purposes, is a bit loose. Rules of evidence have been developed over hundreds of years, and when you get to the administrative proceeding, they're very relaxed.
They throw it out or they turn it upside down. You're guilty until you're proven innocent.
They say all the right things at the beginning of the proceeding, that the airman the FAA has the burden of proof, that the airman is deemed not to be guilty of the infraction unless the FAA meets its burden of proof. The words are there. The feeling, most decidedly, is not.
Well, the words, we exclude the video as evidence, but then the actions was they used it over and over again.
A couple hundred times.
That's interesting.
Okay, so you're about to plead the case. Any last thoughts you have on this?
Sure. The amount of energy that's been spent on this case has been substantial. When I say energy, I'm talking resources. When I'm talking resources, I'm talking money. Trent's original suspension was 120 days. I'm sure a lot of folks are asking, what's the big deal? The big deal is the rule of law. That's why the fight has been so hard pressed. And bear in mind, too, AOP has jumped on board. Senator Ted Budd's office from North Carolina has jumped on board. There's more at stake here than just whether or not Trent gets suspended for 120 days or not. It's really about the overarching nature of modern administrative agencies.
Because I said so.
Because I said so. We're giving much away that many folks, our forefathers, have fought for. Nobody's saying the FAA can't make appropriate rules. Nobody's saying the FAA isn't necessary. What we're saying is, look, if you want to make a new rule, there's a way to do that. It's called the Administrative Procedures Act. Go out, publish your standards, let us know where the line is, and we'll stay on the right side of it. But please do not come after us and violate us for something that heretofore you never said was a problem. And in fact, the FAA in its own internal documents say very clearly, if a federal regulation doesn't say you can't, then you can. And yet they don't proceed that way. When they don't like something, they're going to come after you and they're going to shut you down, they're going to suspend you and say you shouldn't have done that when they never told you what it was in the first place. That's not the rule of law. That's because I said so.
No, I agree with that 100%. Well,
So we'll move outside of the administrative law judge. We're now into the federal court system.
Correct.
And so there's hope.
There is hope. And of course, even beyond that, there's some movement afoot to change the law itself.
Good.
Awesome.
Well, Robert, thank you so much.
My pleasure.
You are really busy. You are actually in town at the same time we're shooting these, because I've been trying to get you on the show for some time now. And but you're at the big flight sims near DFW. You're not an airline pilot, are you?
I'm not an airline pilot, but I try to learn all I can where I can, and ATP is a fabulous organization, and we're going back to the Sims this afternoon to sweat a little bit more.
I know you're in a hurry to get back. So thank you
Dan.
so much.
Thank you for having me.
For coming
thank
on.
you so much.
Yes, ma'am. Pleasure.
All right, and thank you guys for watching, and don't forget our sponsors. We have Clemens Insurance. Jerry at Clemens Insurance has saved me a lot of money. Check them out below. We've got 67 Designs, 67D.com, with Marshall Protective Services, MPSProtects.com, Colton Mortgage, Colton Taking Off, and Christy mentioned Flying Eyes,
Z-Vision.
and Z-Vision,
Wow.
XEvision.com. So thanks for watching
We'll see you guys next time.
in the hangar.